In this video, we'll discuss force majeure basics, and we'll also tell you what to look for in your contract, what to expect when making a force majeure claim, and how to do that. Force majeure is a French term that literally means superior force or an act of God. In contracts, it refers to an extreme, unforeseeable circumstance that's unavoidable. Something that nobody can see coming, like a global pandemic crushing the economy and preventing people from physically reporting to work. Considering this coronavirus outbreak and shutdown were largely unpredictable, as well as its impact on the economy, this pandemic will likely trigger most force majeure clauses. What's more, some detailed force majeure clauses will actually specifically cite a pandemic as a trigger for the clause. So, in that case, it'd be pretty cut and dry. Remember though, a force majeure clause isn't simply a license to stop work. The terms of the specific clause will be very important, and you'll need to show that you tried to carry on work as planned. Plus, keep in mind that courts will usually look at these clauses pretty narrowly, meaning it's a bad idea to expect a lot of leniency if a dispute arises over a force majeure clause. And if it's possible, it's usually a better idea to try and move forward with the contract. Finally, just like with payment disputes, open and often communication can help ease the stress of having to rely on a force majeure provision. If you and your customer or your vendors can agree on how to proceed, that will be a lot easier than getting into a contentious dispute and having to fight over the terms of your specific force majeure clause. Generally speaking, it's just a better idea to avoid legal disputes. A common question that we get is, will force majeure affect my contracts? First, unless there's a force majeure clause in your contract, it probably won't affect you. Now, your vendors may have force majeure provisions, your customers may have force majeure provisions, and the terms force majeure might not even appear in your contract, but if the terms act of God or unpredictable event, or if the contract refers to very large global catastrophes, that might be a force majeure clause. Even if a force majeure clause isn't in your contract, other theories like impracticability or frustration might relieve you of some of your duties and obligations under your contract, but those tend to be an uphill battle. So if there is a force majeure provision, relying on that rather than those other theories is a good idea. Further, if there's a force majeure clause, the actual language of that clause will be crucial for determining what rights you have and what responsibilities you have in claiming those rights. Put extremely simply, it will usually come down to two things. One, is your force majeure clause triggered by this coronavirus scare or the government shutdowns or the fallout of either event? And two, has that affected your ability to perform such that you need to claim a delay, to suspend the work, or to terminate performance either entirely or in part? If it's become impossible, illegal, or impracticable to continue performance, then you might be entitled to relief under your force majeure clause. You may be wondering, how will force majeure affect my project specifically? To break it down simply, potential rights under a force majeure clause will usually be an extension of time, an excusable delay, a suspension of performance, or the right to partial or total termination of the contract. For example, if your workers weren't able to report to the job site due to the coronavirus pandemic and a government shutdown, then you might be able to get an extension of time based on their inability to report to the job site. But ultimately, it all depends on how the force majeure clause was written and how the event specifically impacts your work. In a situation where your work could continue, maybe as an essential business, force majeure might not be as good of a crutch. Again, just because an act of God happens doesn't mean that you can just lie down. You still need to directly tie that force majeure event to your situation. Plus, you'll also have to show why your work couldn't be completed or why those hurdles were just insurmountable and you couldn't continue your work. Some important factors when considering a force majeure clause are: did the event cause the delay or the inability to perform your specific work? Were the circumstances completely out of your control? And did you make any efforts or take any reasonable steps to mitigate those issues? So for example, if you're a roofer and if your state allows for roofing repairs to continue under the stay-home order, then a force majeure event like coronavirus might not excuse your performance. If you fail to show up to the job site or if you fail to even try to continue your work because of the virus, then force majeure might not be a reliable crutch for you. Obviously, it's unreasonable to think that all hurdles could be overcome, but it's important to at least try to make things work. As for how to trigger your force majeure clause in your contract, some contracts will provide specific instructions. Regardless of what's required, it's a good idea to send written notice to the other parties involved. That way, there's open communication, everything's transparent, and it's less likely that things will go down into a legal dispute. On that written notice, it's a good idea to lay out the specific event, how it relates to your work, and why you're unable to perform your work or stay on schedule. And then it's even a good idea to outline some of the ways that you tried to make things work. Obviously, you'll also need to provide the specific ask. So you'll need to tell them what you're claiming, whether that's a delay whether that's for a suspension of the work or whether that's for a partial termination or a termination of the contract entirely. Also, there may be a deadline for sending that notice, so it's a good idea to err on the side of caution and send that notice on the earlier side. But again, refer back to the contract and that'll give you an idea of what that time frame looks like if there is a deadline. In the wake of this coronavirus outbreak and the resulting government shutdowns, the country's headed to a recession, and another common question that we're getting is, will a recession trigger a force majeure clause? Usually, the answer is going to be no. It's possible that the specific clause has terminology that refers to economic downturn or maybe even specifically cite a recession as an event triggering that force majeure clause. But unless it's specifically outlined there, it's probably not going to fly. The economy comes and goes and recessions happen, and there was one not that long ago. So to argue that a recession was totally unforeseeable will be an uphill battle, and it's unlikely that courts will be very lenient there. We hope this video was helpful. If you have additional questions, please feel free to come to Levelset's Expert Center, where you can ask questions and get answers from licensed construction attorneys. Additionally, we have some links in the description of this video that should be helpful to you. And remember, payment help is here.